Well, today is the 18th of May 2026, and I'm in the library at Angela Ruskin University in Chelmsford, and I've done a number of talks and lectures, as you can see by looking at my YouTube or in fact LinkedIn, on various aspects of law, particularly some more recent developments. I'm going to do this next talk about jurisprudence and try and relate it to what's happening in the world today. It's a deep regret to me, and I think it's a mistake in the academic world by stopping the teaching of jurisprudence. Jurisprudence is more than just teaching the law. Teaching the law at the basics level that we do it is simply giving students a list of facts, a question, and then applying those facts. They'll say this is the law, and then ask them to give a narrative answer to that issue of applying that law to those facts. But of course, philosophy of law is a lot different. It talks about why the law exists, what's a good law, what's a bad law, what should be part of the law, what shouldn't be part of the law, what element should be in the law, for instance. Morality is the big one, human traits, sociology, economics, ideology, what should play a part in the making of the law. And then we turn to the enforcement of it. And then there's the distinction between jurisprudence in the state-made law, country-made law, and jurisprudence in the idea of international law. So this is going to take some time, and I intend to break it up into sections. I'm trying to keep each section to about 20 minutes. I'm 75 years of age, and 76 in a couple of months' time, and I feel still a fervour, enthusiasm, passion about the law. And I don't know if universities are teaching that. I don't even know if the practical courses are teaching at it. It's all got very secular. It all seems to relate to money. I mean, the most vulnerable people in the society and the poorer people in the society, can I make the suggestion, are probably the majority. But no lawyer can make a living representing the most vulnerable in this democratic society in the United Kingdom, because legal aid is not in favour. In fact, politicians spend most of the time criticising lawyers that look after the most vulnerable. That's new. That never used to happen. Politicians criticising court decisions and so on. Times are changing. So we're going to have a look at various ways that previous writers, philosophers who looked at the law, and maybe you can gather some of the way that we should approach enforcement and creation of law and try and make the world a safer and better place. It's always annoyed me that at the age of 50, I had no real pension to talk about. I was a legal aid lawyer when there were legal aid lawyers. I think there's hardly any nowadays. And if they are legal aided, well, there's probably a private side of the practice keeping them going. But that depends on the firm. I mean, why would a firm have an office with a legal aid lawyer earning about £60 an hour when they could put a commercial lawyer in there earning $1,500, according to the last thing I saw in the newspapers a few weeks ago? $1,500 an hour is what some of the major cities firms are producing. Now, you're not going to tell me that those lawyers are any better than legal aid lawyers in terms of academic equality or intelligence. Of course not. It's just that society values their clients are able to pay more for their services than the poor are able to pay for mine. And it's dreadful to have to go to a college and school and university and talk to aspiring lawyers and tell them there's no career in representing the most vulnerable, and invite them to do it as pro bono or to run it as part of another part of a practice. And where is the integrity gone? Anyway, I'm not going to lecture about qualities to enter the profession. I do give talks about that, and I am always accessible while I'm still alive, so don't leave it for too long, to anybody through LinkedIn who thinks I can help out. I get a lot of pleasure from doing it, and I get a particular buzz when one of the youngsters that I've been involved with suddenly does well and gets his brand new wig or whatever the case may be. It makes me feel good, which is why I do it all for free. Also, of course, I'm not sure if there is an afterlife or a God, but I'm investing in my life after death, just in case there is. It's a typical lawyer move, hedge your bets. Anyway, let's make a quick start, and I've only got 15 minutes or so to stop to lay the groundwork for what I'm going to be covering, and some of it's going to be read because simply it's too complex to just sit here and just rattle it all off. So, jurisprudence. Why do we have it? Why is it important? It depends on where you're coming from, because if you're studying politics, philosophy, law, for example, you'll have a different take when you look at philosophy in relation to law or in relation to the subjects that you're doing. I should make a point here that I've not used AI in anything that I'm going to tell you about. And I've got to tell you, I think professionally, youngsters should avoid using AI at all. I think it can get them unstuck. It affects their professional ability to practice and judge. And I do think actually we need to look at that. There's a street of difference between young lawyers making mistakes in relation to inexperience and maybe even stupidity than there is dishonesty. We need to be quite clear about that, and the Professional Standards Board sort of have some compassion when looking at the stresses that lawyers are under in relation to what they've done. Education's far better, in my judgment, for reasons I will talk about, than punishment very often. Right. So far as the content of what I'm talking about, how do I give attribution? I can't give attributions because I got it from different sources, and I'm not an academic, and I'm not writing a book. So, I mean, I listened to some lectures on the internet. I read some books on the subject, for instance, like this one, Juris and Jurisprudence, and a few others. I looked through those, so I cannot really give a bibliography, but if there is anybody that recognises any of the contents of this, I give them my thanks if I in fact used that bit and they didn't use it for somebody else. So anyway, grateful thanks to those that have contributed to this discussion. Now, can I also say that when I finish this, you may agree with me, you may not agree with me. And that matters less than the fact that you are now in a position to argue about it. And that's really what jurisprudence is about. It's why the law's there. Why are we lawyers? That's it. That's the importance. What's a good law? What's a bad law? Anyway, why are these theories important? We'll look at the main ones. I can't cover everything. So firstly, what is jurisprudence? Well, to say it's hard to define is an understatement. One definition refers to case law. So, for instance, jurisprudence of the International Court is its case law, and jurisprudence of the common law is its case law. And I'm not going to talk about case law. I should also say there is a academic argument about whether, in fact, there's a distinction to be made between jurisprudence and international law. In any event, anyway, so forget about case law. So what am I going to talk about now? I'm going to talk about the philosophy of law. So the philosophy of law is different from jurisprudence because the philosophy of law started a long time before the term jurisprudence was used. I think it was used, on the researches I've done, around about 1600. But it's far more ancient than that. So jurisprudence is the study of legal philosophy. It is conceptual. And if interested and you want to go further with this, you'll have to investigate further. It may well be that I might type up something of this talk to you and put it as sort of like a leaflet or something online. Maybe I will. And then perhaps if I charged £1 for it, I could donate that to the Legal Aid Fund, which seems to be struggling. No. Solicitor Benevolent Fund, maybe. I don't know. Anyway, enough frivolity. So it's conceptual. Some of the theories that I'm going to discuss are separate. And I think for the purpose of study, it's best to keep it separate. So the terminology and labels, I'll try and separate, but they are mergers, and some of the writers do merge them. I will pick a bit here and I'll choose a bit there when looking at particular legal questions I find interesting. I am not a philosopher of law. I'm not a trained academic in jurisprudence, but I love the subject. So there may be errors and there may be my opinion. Who knows, maybe one day somebody will say Dworkin, Hart and Chatelier's theory of mankind and law. Right. I will mention from time to time the current state of our legal system, possibly related to sentencing, access to justice, protection of democracy, which I think is part of this. And one thing about philosophy of law, I think you can more or less bring in anything to it, really, if it's relevant. To me, I think all this argument with all the philosophers that we're going to discuss, to me, what's wrong with the word relevance? Anyway, you'll see what I mean when I come to it. I would dearly love to explore in more detail jury trials and the prohibition of Palestine action, which is contemporary news to now where I'm dictating this. But if you look online, you'll find that I have actually devoted a more general description in relation to what I think about jury trials and jury equity. I'm a fervent supporter of the democratic right of juries to decide what's necessary. I mean, for goodness sake, the Magna Carta, I think, was 1215. We're given the right to be tried by our peers. And so that's been centuries in existence. And lo and behold, through some sort of political, ideological expediency now, without any real thought, we decide we're going to change it all. And change it all in terms of practical discussion, not in terms of philosophy and what the wider pictures are. But hopefully at the end of these discussions, you will be able to at least enter into discussions and argue a bit more widely. Right. I'm going to look firstly at natural law theory first. Natural law theory is probably the start of jurisprudence. It's the start of the philosophy. In terms of most academics. However, legal philosophy started long before them. It's ancient Egypt, I think, is where it first started. But of course, the relevance to us in discussion now really starts a bit later than that, in the times of Plato, Aristotle, and Socrates. And so that's where natural law theory started for our purposes. And then it moves on to the religious influence of medieval times, i.e. the Christian revival. And of course they brought with it those religious influences in medieval times. these theories will provide exciting ways of looking at the law. But what I like about natural law theory is that it holds the belief that morality is inherent in human behavior and reason. Now, natural law says natural law is what the law should be, and natural law says that morality and law are connected. So we talk about morality here. I noticed when I was going through all of this is that there doesn't seem to be a word anywhere or a theory anywhere which seems to include the word integrity. Integrity of the lawmakers, integrity of the enforcement, and integrity of the people. And so please bear that in mind. So when I'm talking about these things, remember, there's no mention by these philosophers of integrity. The philosophy, according to Travascitelli, talks about integrity. So, why is jurisprudence important? This lies in the difference between descriptive or narrative law and jurisprudence. So, descriptive narrative law, that is what you're taught in universities at the moment. You're provided with a factual problem, you're given the law, and you're asked to find the answer in relation to applying the law to those facts, depending on which side of the argument you're asked to defend or prosecute, or an impartial view, depending on what it is. But basically, it's applying the law to the facts. That is natural law. So, contrast that with jurisprudence. Jurisprudence allows us, and you particularly, because I won't be around, I don't suppose, to argue this much longer. I mean, I'm already forgetting where I leave things lying around. But this gives you the ability to challenge the fundamental nature of law. What should the law be? Is the law right? Is the law wrong? So jurisprudence is a study of the different theories that affect those decisions. How do you enforce it is one I would add, and it doesn't seem to be looked at in the same sort of level by most of the writers that I've looked at. So acceptability by the society that you're trying to influence, or the states in terms of international law, is their acceptance or their compulsion in respect to those laws are important. Right, so this is not a discussion about, let's say something easy, Section 1 of the Theft Act. It's a question of law as a abstract entity, more philosophical. We'll look at how it developed from ancient times. I'm sorry to belabor the difference because it's conceptual. I'm trying to put it in different ways so that you might just get the drift of what I'm talking about. Then, after natural law, we're then going to look at the other most important feature of jurisprudence, which is called legal positivism. Legal positivism. That's had the most important effect on modern jurisprudence. Legal positivism, in a nutshell, I suppose, is trying to say that the law depends on legislation, judicial decisions, custom, not much to do with morality. Morality is disconnected. Natural law, morality is part of it. So it's a disconnect. And of course, that would be too simple, wouldn't it? Just saying one's got morality attached to it and one hasn't. So natural law has morality, legal positivism doesn't, of course. And of course, nothing's simple, particularly in philosophy and law. And so we got loads of writers that have put glosses on both these arguments. So let's start with the natural law of the Greeks, and then looking at the arrival of Christianity, which is still important today, of course, but of course now we have other faiths in our state, and certainly the United Kingdom, and indeed around the democratic world, where of course their customs and beliefs are relevant to be discussed in terms of looking at what should be a law, what shouldn't be a law, and so on. Legal positivism is, I think, to be honest, the most important and the most important philosophers about legal positivism are more recent. So this is L.H.E. Hart, and by way of criticism, Hart, a later philosopher called Dworkin, D-W-O-R-K-I-N. Both, I believe, were chairs at Oxford University, one following the other. In fact, Hart came first, and then Dworkin succeeded him. And more recently, of course, contemporary theories relating to law and society show that sociological, economical, political, and more liberal approaches are playing a part in the criticisms of jurisprudence and legal positivism. Marxist theory is also relevant to this, which I'll look at. Feminist theory is also relevant to this, which I'll look at. And race theory and so on. I can't cover all these influences. Suffice it to say that they're all relevant to a discussion, but they don't necessarily play a part in the base of whether a law is a law or a law is not a law, whether it's not dependent. Some of these arguments are not dependent on making something a law. There's an argument about that, and so we'll come to that, and that should get a little bit clearer with illustration as we go. Now, I do refer to jury trials, as I said at the beginning, and jury equity. Jury equity at the moment is where it's a common law power, which I've talked about in more detail in another post, but it's where really a jury tried by its peers can actually go against the law and disregard the law because we can't go behind a jury verdict. That's a very interesting part of the law, and there is a really interesting post, I think, and even though I wrote it myself, that I really recommend you go and have a look at. It really shows you the farce of the whole system in respect to that, and we really need to look at jury equity, particularly when we're talking about reducing jury trials and getting judges to do everything. I lie on the side of jury trials. Anyway, so I'm going to stop this now, and the next video is going to be dealing with the first question of what is natural law.